Hello, everyone, and welcome to Uncivil Law, where we learn from the misfortunes of others. As always, I hope you enjoy this legal education content, and today is the day I earned that subscription. For today's story, we are dealing with privacy and cell phones, and it seems that your privacy on your cell phone may not be as private as you wanted, because Google has just had to reach a settlement of $400 million because when you turned off location tracking, they were tracking your location. So the turning off the tracking of the location and the location of tracking were somewhat disconnected. And yeah, so there might be some issues there. So Google has had to pay this largest privacy related settlement possibly ever, $400 million to 40 states. Let's learn a little bit more about this. In what is considered to be the largest privacy-related settlement in history, Google will pay $400 million to 40 states to settle an investigation. The coalition of attorneys general alleged that Google misled its users into believing that opting out of sharing of location data prevented the company from tracking location, because that would be a logical conclusion. If you opt out of location tracking, then you can't track my location. But even when users opted out of location tracking, researchers confirmed that Google tracked location across a number of its services, including search tools, map, and application. The practice, which occurred between 2014 and 2018, violated state law dealing with misleading of consumers. So for at least 6 years, and God knows what else is true, these apps Google was keeping track of your location data, even if they said they weren't. For 6 years, it's like, well, we aren't tracking your location, except we totally are. And it makes you wonder about all the apps you have on your phone, about what apps say they're not tracking your data and what apps are tracking your data. So it's a little bit of concerning. User location, of course, was then sold to advertisers who used the data to provide targeted advertisements to consumers based on locations. The attorneys general's claimed the location data was a key to Google's advertising business, which it said generated more than $200 billion in ad revenue. So that $400 million fine in the face of $200 billion of ad revenue, well, not to put too fine a point on it, but it's a rounding error. In addition to the significant payout, the company also agreed to improve its disclosures. In a blog post, Google assured that it would soon provide users even greater controls and transparency. I know I feel assured. The record settlement comes in the midst of increasing pressure from states and federal lawmakers to revamp corporate privacy practices. Proposed federal legislation seeks to regulate and apply a greater scrutiny to privacy practices, including by allowing federal, state, and private causes of action for private violations. I'm not necessarily opposed to this. I mean, we'd have to get into the details, obviously, but having some standards for some privacy violations and allowing private causes of action for violations sounds like a pretty good thing. Such legislation would permit these lawsuits nationwide. Although the legislation is not currently expected to pass in its present form, it shows momentum behind the issues, which, to be fair, sometimes these issues take a long time, which is also a problem, but that's the way Congress rolls, right? It takes sometimes a couple different versions and a couple different things to find something that people work with all the constituents. So yeah, but this is a real problem, especially if you thought you had privacy. It's like, oh, maybe I don't have privacy. Oh, okay. The current statutory landscape also provides state-specific avenues to challenge privacy practices, as 5 states, including California, Colorado, Connecticut, Utah, and Virginia, have comprehensive consumer data privacy protections, but among these, only California provides a private cause of action. Other states have introduced privacy actions to deal with other aspects of privacy. For example, Illinois is Biometric Privacy Act that creates a cause of action that served as a basis of several judgments, including $228 million against BNSF Railway, resulting from requirements that truck drivers provide biometric identifiers to access corporate facilities. The social media giant TikTok also has entered into a $92 million settlement to resolve a class action based on its biometric privacy violations. Apple has also recently been sued in California under California's Invasion of Privacy Act for its own data collection privacies. Similar to Google practices that prompted the settlement, the lawsuit alleges that Apple tracks and shares application data across hundreds of thousands of users despite disabling it. 3 states and District of Columbia have also sued Google in respective jurisdictions in January 2020 for more location tracking practices. As far as settlement, Google has also approved $85 million in settlements by a state action brought by Arizona, which again seems like a bit of a rounding error for Google. So Google's had to pay $400 million in 40 states to deal with some privacy issues, $10 million a state, which doesn't really sound like very much, to be quite honest, for 5 years, 6 years worth of collection of data. So that's less than $2 million per year per state for Google. I'm sure they're quaking in their boots. But this is what our respective states' attorneys generals have compiled together. So all those good things. So that's what's happening, and that brings to the end of the discussion of that story.